Hi, Ala.
Hello, Mindaugas. Good morning. I'm very, very sorry for my absence during the time slot allocated to me. I had a terrible problem with the internet connection, but now it seems like everything is
all good.
normal.
Actually, all good. This is the life. This is the life we live in. I mean, this is the online life, and it's unavoidable. So my pleasure to present Ala Krinickytė. She's data protection lawyer at NOYB and PhD student on data portability at the University of Vienna. She previously worked at the EU Agency for Fundamental Rights and European Law Institute, and currently she's developing a strategic action with NOYB to enforce the right to data portability. Ala, the floor is yours.
Thank you very much, Mindaugas, and good morning, ladies and gentlemen. I indeed am very happy and proud to be speaking at the Lithuanian conference today, being a Lithuanian myself. As Mindaugas mentioned, I work at NOYB. That means that I'm based in Vienna, Austria. NOYB is an organization that was founded by a person whose name has been mentioned a couple of times, at least his surname was mentioned a couple of times today. And it's Max Schrems. Max Schrems stands behind the two cases on international data transfers at the European Court of Justice, with the most recent decision coming out, the most recent decision that came out in July 2020. I, however, decided to not talk about the international data transfers today because a lot has been said and indeed done with the European Court of Justice, confirming twice companies cannot send European data abroad to third countries if the country of destination does not offer sufficient protection of such data. I have therefore decided to speak about another important topic that has been neglected for a while and that has not received too much attention recently, the right to data portability. So the right also concerns the data transmissions or data transfers if you want, but it concerns the transfers and the flows of data between one controller to another, not necessarily between the controllers in the European Union and abroad. I will share my screen for the presentation. I prepared only a couple of slides which will help visualize the topic. I hope the screening is going well. So the right to data portability is a problematic one, and the title of my presentation is whether the data portability is just a right in theory. And it seems like currently it is just a right in theory, the right that doesn't really work in practice. I will try to explain what the reasons for this lack of correct implementation of the right are, and will also explain a little bit the objectives of the project that we are working on at NOYB. So the right to data portability offers two options to users, to data subjects, and these two main options are, first of all, a user has the right to receive data concerning him or her from the controller and transmit this data to another controller. Another option is to request one of the controllers to send personal data directly to another controller. However, this second option is conditioned by technical feasibility. And as we are talking about the technical feasibility, I would like to hang on here for a second and say, indeed, the right to data portability is a very technical right. It's probably one of the most technically demanding rights under the GDPR. The data portability is a very new right. It has been introduced for the first time under the General Data Protection Regulation. It never existed under the previous Data Protection Directive. And therefore, the controllers and also the data protection authorities, they are not very well acquainted with this right. They don't really have a sound understanding how to deal with it. The courts have not provided any interpretation on how to treat the data portability right. So the first tier of the problem is that there is a low awareness about the right, both among the controllers and the DPAs, but also among data subjects. One study by the ICO showed that only 30% of the people surveyed were aware of the right to data portability. The second problem, or I would say tricky part of the right to data portability, is that this right is not 100% a data protect. It doesn't derive 100% from the data protection law. The right comes from the competition law, and it was initially supposed to ensure a good competition on the market and to break the lock-in effects of big platforms and to release the data that these platforms hold. Another purpose of the right is to empower the individual to have more control over their data. So the idea there is that the data subject should be free to decide whatever they want to do with their data, when, how, and who will receive the data. And looking at the right to data portability from the user perspective, I identify several issues that data subjects and users they face them very often when they exercise the right to data portability. First of all, when it comes to the transparency and how much information there is out there about the right, you would probably notice if you go through the privacy policies of the major platforms, major service providers, that there is little to no information available about the right in the privacy policies of companies. If there is a mentioning that the user has the right to port their data from one controller to another, then that there will probably be only one line saying that you have the right to data portability, without any instructions about how exactly users can exercise those rights. The second problem is that controllers very often confuse the right to data portability with the right of access under Article 15 GDPR. Basically, when a person sends their request that they want their data to be sent from one place to another, they usually get a very standardized response that in order to get access to the data, one can go and follow the link and download their data, and then the instructions stop at that point. Controllers don't really explain how users can then take the data to another controller. The receiving controllers provide almost no information about how the data can be uploaded to their services, which means that as soon as the user gets access to the data, gets the package, the portability package from the controller, they are basically left alone without the real live tools to send the data to another entity. And the third issue is that as an individual, I try to exercise the right to data portability, and what I notice is that usually I get either too much data or too little data, and the right to data portability under Article 20 defines clearly what categories of data, what's the material scope of the right. And as a user who lodges such a request, I can obtain the data that I knowingly and actively provided to the controller, as well as the data that the controller observed about me. Not more, no less. As I said, because of the confusion of the data portability right with Article 15, controllers very often dump lots of data, a huge data set, a zip folder with both inferences, so the data that was inferred through the use of some automated tools about the data subject, as well as some basic information. And the data subject is left alone to decide which categories of data fall under the scope and then which categories they can take to another controller. That also means that the format of the data that comes from the access request, from the Article 15 request, very often does not fulfill the requirements of the data portability. The format in which the data should come, in which the data subject should receive the data, should be structured, commonly used, and machine readable. That's, I would say, the biggest advantage and the biggest feature that makes the right to data portability so unique under the GDPR. And the last and the main problem is the technical feasibility. Of course, the companies currently, the big platforms, they all use different data formats, the data structures to process personal data. Therefore, when a user submits a request to one company asking them to directly send data to another company, there is a high chance that the company does not have an interoperable format in which they can send such data. And because the General Data Protection Regulation does not contain any interoperability obligations yet, these issues cannot be solved on a level of the communication between two providers. The data subject, I feel, is left alone there with a burden to decide and to select carefully which controllers he or she wants to take their data from and bring the data to. And right now, as far as we are aware, only a handful of companies are offering some degree of portability, some degree of interoperability between their systems. And there is a project called the Data Transfer Project, in which big players like Google, Microsoft, Twitter participate and work on developing standards that would allow for such exchanges of data. Facebook is offering currently a photo portability, which means that a user from Facebook can take their photos and send to a selected number of other service providers. But that portability is only limited to the photos, as well as the newest development with Telegram. Telegram, the messaging app, has recently launched the portability of chat history data, and they now allow for example, WhatsApp chat history to be automatically uploaded to Telegram and be used by the user of WhatsApp. So these are the three examples of where the portability is slowly starting to kick off. I think it's a very good development. It's a very positive development. Unfortunately, it is not working. The ride is not working globally yet. We're looking forward to see the developments after the adoption of the Digital Markets Act, which has recently introduced an obligation, a mandate for gatekeepers to ensure effective data portability. This is a big progress, and we hope that this will facilitate the development of not only interoperable formats and interoperability per se, but also a possibility for users to effectively exercise their right to data portability with regard to gatekeepers, but also with regard to smaller companies, which will be incentivized to develop systems that can receive data and act upon the data. That's it from me for now. I'm happy to take any questions and, of course, explain much more about the right, but within the limited time that I have, I think I will stop here.
Thanks, Sara, for your terrific and great insights on data portability, which is really something which will shape our future in the years to come. I have, before going to the break, which, well, some maybe need, maybe not, I have one question, which is, in a sense, a bit provoking. Would you predict the Schrems 3 case any day soon? And what are your thoughts?
Yeah, so I have here the first-hand information from the Mr. Schrems, who is standing behind the previous two cases. He said that he definitely wouldn't want to have another case titled with his surname. 2 is enough. Of course, we hope that there is no Schrems or Smith case exactly on the same topic, because we think that 2 decisions by the CGU is enough. It's clear, it should send a signal that some things should be changed. Now, when it comes to the solutions, unfortunately, here we are afraid it's more a political decision currently. In 2015, when the first ruling was delivered, people were hoping that with the abolition of the safe harbor, there will be something on the legal level, on the legislative level, that could fix the problem. And the years after, we see that the simple abolition of another tool, which is Privacy Shield, is not enough, and some changes must happen in the country, which is causing the whole problem. We're now looking into the adequacy decision for Japan and the UK, And it will be very interesting to observe how the Commission will evaluate those countries and their systems. Perhaps after this evaluation, we will manage to come to a conclusion about the right solution to fix this.
Okay, once again, thanks, Krinickytė from NOYB. Thank you for your insights and beautiful conversation.